Fine. Mr. Jones.
Well, good afternoon, Madam Registrar Acting. Would you please commence the proceedings?
Good afternoon. Thank you, President. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of the Cooperative Republic of Guyana, judgment delivery in CCJ Appeal GYCV number 1 of 2025 between Satyanand Persaud, Taij Bahadur, and Dhavanie Persaud. The members of the delivery panel are Mr. Justice Anderson, President, and the presiding judge.
Good afternoon, Counsel.
Madam Justice Raj Nasli.
Good day to all.
Mr. Justice Jamada.
Good afternoon.
Madam Justice Ononewu.
Good afternoon, everyone.
And Mr. Justice Ebo Osuji.
Good afternoon.
May we have the appearances, please? Thank you.
Good afternoon, Your Honors. I am Sanjeev Dattadin, and with me is Ms. Mohani Anganu and Ms. Jamila Ali, Senior Counsel. Good afternoon, Your Honors.
Thank you, Mr. Dattadin. Good afternoon.
Good day, Your Honors, if you please. I am Tim Jonas, and with me are Ms. Crystal Abrams and Mr. Lucas Jonas, whom I ask Your Honor's permission to introduce to the court.
Thank you very much, Mr. Jonas. You will be pleased to hear that we have arrived at a decision in your appeal. The decision is by majority, and the lead author of the majority opinion is my sister, Justice Chantel Onaniwu. I will now call upon her to deliver the judgment. Judge?
Thank you, President. The summary of the judgment of the Caribbean Court of Justice in this appeal is not intended to be a substitute for the court's reasons or to be used in any later consideration of the court's reasons. The appellants, Satyanand Persaud and Taij Bahadur, are the uncles of the first respondent, Dhavanie Persaud, who appears both in her personal capacity and as the representative of her late father's estate. While the underlying dispute concerns an allegation that the estate owes the first appellant a $400,000 debt, the scope of this appeal to the Caribbean Court of Justice was limited to a review of the decision of the Court of Appeal, dated 7th October 2024, refusing leave to appeal from the full Court of Guyana. The Court of Appeal struck out the motion for leave to appeal as it was filed out of time. Despite receiving twice from the respondents advanced written notice of the lateness of the application for leave to appeal, the appellants did not file an application for an extension of time to seek leave to appeal prior to the Court of Appeal's hearing of the leave application. At the hearing, the appellants registered a desire to seek an extension of time. However, the possibility of an application for an extension of time was not entertained by the Court of Appeal, which decided the matter on the basis of the motion that had already been filed. The appellants asked the CCJ to grant leave to appeal to the Court of Appeal against the decision of the full court. They alleged that the Court of Appeal had failed to recognize that an extension of time was warranted and had failed to recognize the substantial merits of their case. This court, by majority, Justices Rashnath Lee, Jamadar Ononiwu, and Ebo Osuji, allowed the appeal, set aside the order of the Court of Appeal, and remitted the matter for fuller consideration. Having refused the appellant's request to grant leave to appeal to the Court of Appeal, the court ordered that the parties bear their own costs of this appeal. Justice Ononiwu delivered the lead opinion of the majority, and Justices Jamadar and Ebo Suji delivered concurring opinions. President Anderson dissented, holding that the Court of Appeal did not make any sufficiently grave error of law to warrant remittal, and recommending that the appeal be dismissed with costs awarded to the respondents. As the Court of Appeal did not render a written judgment for its decision, this court ascertained the reasons for the Court of Appeal's decision by examining the transcript of the proceedings before that court. The transcript revealed that in handing down its decision to strike out the application, the Court of Appeal stated that it was guided by the 14-day time limit to seek leave to appeal under Order 2, Rule 2.1 of the Court of Appeal rules. The Court of Appeal also found that the application was about a month out of time and noted counsel's reluctance to withdraw and discontinue the matter. The transcript did not disclose the Court of Appeal's consideration of its discretionary power under Order 1, Rule 8 of the Court of Appeal rules to extend the time for applying leave to appeal if the interests of justice so require. The CCJ emphasized the responsibility of the appellants as the parties in default to take appropriate steps at every available opportunity to protect their interests by making a proper application for an extension of time and for leave. In the absence of a proper application for an extension of time, the Court of Appeal was under no duty to recognize that an extension of time was required in the interests of justice. In circumstances where the appellants placed no proper application for an extension of time before the Court of Appeal for its consideration, it would be inappropriate for this court to determine whether an extension of time and leave to appeal should be granted. The majority considered, however, that the Court of Appeal retained its jurisdiction under Order 1, Rule 8, despite the appellant's failure to file an application for an extension of time. This court found that in circumstances where counsel for the appellants had clearly communicated a desire at the hearing to seek an extension of time, the Court of Appeal had a duty to consider the possibility of the exercise of its curative power under Order 1, Rule 8. The CCJ held that the Court of Appeal erred in law by limiting itself to the non-compliance with Order 2, Rule 2.1, that the failure to file an application for an extension of time deprives the CCJ of jurisdiction to hear a late application for special leave to appeal. The court's jurisdiction to grant special leave to appeal is conferred by statute and cannot be extinguished because a litigant filed a special leave application outside of the time period prescribed by the court's rules without also filing an application for an extension of time. In those circumstances, the court retains the jurisdiction to cure the procedural non-compliance if it considers this necessary to ensure justice is done in the case. In a concurring opinion, Justice Ebo Suji stressed that procedural rules should not bar litigants from justice, and that late filings can be cured, usually by costs, unless real prejudice would result. Justice Jamadar, in a separate opinion, outlined the contours of his agreement with the reasons given by Justices Ononu and Ebo Osuji, respectively. In his dissenting opinion, President Anderson stated that he saw no good or sufficient reason for a remittal of the matter to the Court of Appeal, which will likely prolong the litigation unnecessarily. He stressed that the Court of Appeal's discretion under Order 1, Rule 8 must be sparingly exercised, and that the onus was on a litigant in non-compliance with the rules and who desires the benefit of a favorable exercise of that discretion to supply the court in advance with all material necessary to facilitate that exercise, including strong reasons explaining the non-compliance with the procedural rules. President Anderson also endorsed the previous jurisprudence of the court, affirming that in the absence of the risk of an injustice, the court has no jurisdiction to allow a departure from the procedural rules so as to overlook the late filing of an application for leave to appeal or special leave as the case may be, where no application for an extension of time has been filed. To suggest that there was a discrepancy between stating that the court had no jurisdiction to hear a late application for leave to appeal and the court's finding that it would be inadmissible to entertain an application for an extension of time where there was no risk of miscarriage of justice in not extending time was simply an optical illusion. This is the summary of the court's judgment.
Thank you, Judge. Any comments from counsel?
Thank you very much, Your Honor. No comment.
Thank you, Mr. Dattedin.
Thank you very much, Your Honors. No comment.
Thank you very much, Mr. Jonas. I think that this brings our time together to an end, and I will therefore ask the registrar acting to officially bring an end to these proceedings. Madam Registrar.
Thank you, President Anderson. Thank you, Madam Justice Rajnosley. Thank you, Mr. Justice Jamra. Thank you, Madam Justice Ononu, and thank you, Mr. Justice Sebo-Suji. Thank you, Counsel, and a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you, ma'am.
Thank you very much.